I will call the Senate Committee on Judiciary to order. Will the Secretary please take the roll?
Senator Harris.
Here.
Senator Dondero Loop. Senator Ordershaw. Senator Wynn. Senator Hansen. Senator Krasner. Senator Stone. Chair Scheibel.
Here, thank you so much. We have everybody present, and we have a couple of bills on for hearing today. I was noticing on at least my copy of the agenda, SB 418 is listed for a hearing this afternoon. We already heard that last week, so if you're here for SB 418, I apologize for the error. We have been furiously scheduling all of the bills that we have left to be heard in the next 2 weeks, and this was just an error in our calendar. But we do have 3 bills on for hearing this afternoon, and I believe they're all going to be presented by our esteemed majority leader. Would you like to take them in the order they're on the agenda, which is numerical? Or is there one you'd like to hear first? All right, then. I will open up the hearing on SB 309.
Good afternoon, Madam Chair and members of the Senate Judiciary Committee. It is great to be with you all here today. It's definitely a committee that I have missed, so it's great to be here with everyone to present to you Senate Bill 309. For the record, my name is Nicole Canizaro. I represent Senate District 6 in the northwest portion of the Las Vegas Valley, and I'm here along with an intern in our office, Saha Salahi. Sorry about that, who is going to help me to present this bill. This bill creates the crime of fertility fraud and includes additional provisions related to that crime. For members of the committee, this bill actually came to me from some work that not only Saha has done on it, but also some other individuals in my office before session to put together something that we thought would make sense to address what has been an ongoing issue that has gotten some more recent media attention. And so I want to give a huge shout out to some of the folks who only know who they are, some staff who have worked on this very diligently, brought it to me, made the case for why they thought it would be a good policy for us to hear at the legislature, and then Saha took an immediate interest in that as well, and so I'm excited to be here with her today to help present this bill. As you may already know, since there have been several high-profile cases of fertility fraud reported in the news over the last several years, fertility fraud occurs in the field of assisted reproduction when a fertility doctor inseminates a patient with their own sperm without the consent of the patient, or when a donor's eggs are used without their consent. These are 2 of the most common types of fertility fraud, but there are others as well, and I believe that the language of Senate Bill 309 is meant to address some of those additional circumstances that may present themselves when we are talking about fertility. And I think at the heart of all of this, the core tenet of what we are trying to address is that if you are seeking fertility treatment, in any fashion, that what it is you as a patient show up for is what it is the treatment you will get, and that there aren't misrepresentations made, that there aren't more nefarious means used to use reproductive material that is not consented to by the patient, and to ensure that we are making a statement as a state from a policy level that we want to make sure that when you are seeking fertility treatment, you are getting the treatment that you as the patient are looking to receive. And so that's sort of, I think, in terms of broad themes for Senate Bill 309, what we are trying to do. I, of course, am very excited again to be here with Saha, who is currently at UNLV. She is a student who is studying a communications major degree and a public policy minor degree, which makes her very well adept at the legislative process. And if it's okay with you, Madam Chair, I would like to turn it over to her. She can shed a little bit more light on the issue of fertility fraud, and then I will walk through the sections of the bill, and we'd be happy to answer any questions.
Good afternoon, Chair Scheibel and members of the Judiciary Committee. My name is Saha Salahi, that's S-A-H-A, S-A-L-A-H-I for the record. With your indulgence, Chair Scheibel and members, I'd like to speak briefly about the 1991 Nevada Physician of the Year. Dr. Quincy Fortier was a Nevada fertility specialist who had been considered an esteemed member of his field as a commander of a medical reserve unit at Nellis Air Force Base. He had been elected to the Southern Nevada Memorial Hospital Board of Trustees and was instrumental in the growth of Faith Lutheran Academy. Despite his medical expertise and high regard within the professional community, the doctor inseminated his patients with his own sperm, without their knowledge nor their consent. Recently, through the use of DNA testing kits, many dozens of families concluded that decades ago, their doctor violated them during one of the most vulnerable visits to his clinic. Dr. Fortier's lawyers use the defense that Nevada law doesn't explicitly say doctors cannot use their semen on their patients to aid in fertility treatments. In the past few years, Indiana, Iowa, Arizona, Arkansas, Colorado, Kentucky, Utah, Texas, and Florida have enacted laws on fertility fraud. As of 2019, doctors who use their reproductive material to inseminate patients in Texas are able to be found guilty of sexual assault and face a felony charge in the second degree. In March 2021, the state of Utah decided to use of a doctor's reproductive material without the patient's consent is a third-degree felony. California has had laws enacted since 1996, which constitutes fertility fraud a crime, punishable by a sentence of 3 to 5 years and a fine of up to $50,000. It's unsettling, to say the least, to find out that this human rights violation is currently legal in our state, and that doctors have never been charged for participating in such a violation. Nevada has recently been known for being the first state legislature to have a female majority in the nation and putting women's rights in the forefront of policymaking. However, the lack of recourse for this heinous crime has been more than frustrating. It has been shocking. Until legislative changes are enacted in Nevada, it's feasible that a doctor could continue to violate their patients with fertility fraud today. It is my hope that patients in the state never have to experience that of the patients under the care of Dr. Fortier. The doctor's case ended before a judicial decision was reached due to his death, leaving a loophole in Nevada law open, and an opportunity and a duty for our legislature to close it. With that, I'd like to turn it over to Senator Canizaro to further explain how Nevada could finally join other states in explicitly criminalizing fertility fraud.
Thank you, Madam Chair. Nicole Canizaro, Senate District 6. So moving to the bill and its specific language, I'm going to walk through each of the sections where there are changes. Sections 3 and 4 define the terms of assisted reproduction and human reproductive material for the purposes of the bill. Section 5 creates the crime of fertility fraud as a Category B felony, which carries a prison term of 2 to 15 years and a fine of up to $10,000. This crime occurs when a healthcare provider knowingly implants his or her human reproductive material in a patient without express consent, or when a healthcare provider knowingly uses human reproductive material other than that expressly consented to by the patient. Section 6 creates the related crime of fertility fraud in the instance of a person other than a healthcare provider knowingly conveying false information to a patient concerning the donor or the human reproductive material to be provided to the patient. This violation is a Category C felony. Sections 5 and 6 both provide for the notification of appropriate licensing boards by the Attorney General upon conviction for either of these crimes. Sections 7 and 8 provide that a civil cause of action may also be brought within 3 years after a victim discovers fertility fraud, and provides that a victim may also be a spouse, a child, or a donor, and that each child born as a result of the fraud constitutes a separate cause of action. Section 9 adds fertility fraud to the list of sexual offenses for which a court is prohibited from ordering a victim to take a psychological or psychiatric exam, and sections 10 and 17 add fertility fraud to the list of sexual offenses for which lifetime supervision is required. Sections 11 and 12 add fertility fraud to the list of sexual offenses for which an offender may undergo a psychosexual evaluation and for which a court is prohibited from granting probation or a suspended sentence until that is completed. Section 13 provides for victim and witness notification upon a conviction, as is done with other sexual offenses, and Section 14 prohibits the sealing of records for this offense. Finally, Sections 19 and 20 provide that a health care facility shall not provide a patient with human reproductive material except in accordance with an agreement entered into between the patient and the facility and the donor in the facility. A violation of these provisions carries a civil penalty of $10,000 per violation in an action to be brought by the Attorney General on behalf of the state. A facility that violates these provisions is also subject to license suspension or revocation by the Division of Public and Behavioral Health, Department of Human Health and Human Services. And for members of the committee, I recognize that this is creating a crime that has additional criminal penalties, and some of which are quite steep. I would submit to the committee that undergoing fertility treatment, no matter the reason why you find yourself in that position, is already difficult enough for a whole litany of reasons. That you're going to put your faith into a healthcare provider who is going to help you to build a family and to have a child, or to help contribute to another family who is having a child. The last thing that those patients should be worried about are providers taking advantage of that for what I can only articulate as very egotistical and narcissistic, nefarious means. That just can't be tolerated in these types of circumstances. And so I think that while we have a lot of providers who obviously provide very competent care and provide a level of care which we can trust in, we also know that there are, and there have been even in Nevada, examples where that trust has been breached. And it is, to me, akin to someone who is taking advantage of someone for other types of sexual related offenses. And that's why it was created also as a sex crime. I think there are a lot of things that mirror one another and go hand in hand with that. And to take advantage of someone who is not only paying what is likely a fortune for that treatment, having to be in a difficult situation in the first instance, to then put them through this, I think warrants a very high penalty. I don't think that there's an excuse. I don't think that there is a reason for this to happen. This was not, this doesn't constitute a crime where someone mistakenly is in this position, and certainly I think we can talk about those pieces of it. But this bill was intentionally written with some steep penalties because I think that this is something that should be addressed very appropriately, and should reflect that, and should reflect the position of the patients who find themselves, who may be the victim of this particular crime, which I am hoping there are none, and which I am hoping this helps to make sure that our healthcare providers know that this is not the place for that to happen. Additionally, what I wanted to also note is that I know that Saha mentioned there are several states that have considered legislation. We went through and they did a huge analysis of all the different bills that have been passed in other states. Ours most similarly replicates the version that was passed in Iowa. And many of these bills are being passed with a lot of robust bipartisan support. So with that, Madam Chair, I would like to open it up for any questions from the committee that we may be able to answer.
Thank you both for your presentation. We certainly appreciate it. Are there questions from members of the committee? Vice Chair Harris.
Thank you, Chair Scheibel. So you mentioned during the presentation that the defense was able to use an argument that the law does not explicitly prohibit using the doctor's own semen to inseminate. Do you have any idea why that argument worked, right? I mean, doctors, if they are supposed to perform surgery on your left leg and they actually perform surgery on your right leg, it doesn't matter if there's a law that prohibits not performing surgery on the right place, right? And so it seems to me that this should fit well within some established form of assault or battery. Any idea why that's not, an analogous example?
Thank you for the question. Saha Salahi for the record. So when looking at the case, one starting off, they said that when it comes to fertility in general, donations are very, very expensive to get, right? As well as there's a lack of donations when it comes to that sector. So the argument in this case was that it was for the means of making it an easy way to go. And because of his death, they just closed the case with knowing that he had so many accolades to back him up. So it was just a very horrible instance of what is possible if we don't have laws in place to basically enact fertility fraud as a crime.
And if I may, Madam Chair, Nicole Canizaro, Senate District 6, through you and to Senator Harris.
You can go direct.
Thank you. So I think that, Senator Harris, you've shone a light on exactly what my question was when this was brought to me. I sort of said that I think I had the exact same reaction. Why would this just constitute an assault or battery? Why wouldn't this fall under some other provision? I think certainly, potentially, if somebody wanted to sue for medical malpractice, potentially you might have a case there, right? And I don't know, because that wasn't the case that was presented here in Nevada. And I think that you might be able to make a claim in that regard. But in terms of assault or battery, I think the hardest part about it is that because you're undergoing fertility treatment, it's not that you didn't consent to a fertilization or to a transfer or to some sort of IVF process, right? And so it doesn't quite fit. And I think that that's where the struggle was, because that was honestly my question was, well, why do we even need this if it feels to me like maybe there were some other statutes that might encompass it? But I think that was one of the struggles with the case here in Nevada was there isn't anything that really fits this. It's a pretty unique circumstance. And because there are a lot of, well, I'm going to consent to this happening, and it's not as though there was a mistake made, and in your example, I think is a great one in terms of maybe the medical malpractice piece, right? There was something that happened that was maybe unintentional, maybe that was done because someone wasn't meeting the standard of care under their practice. This also doesn't really fit. It's not necessarily a standard of care issue, and it's not a mistake. It's someone who is intentionally taking advantage of a very vulnerable situation and then arguing, well, this is appropriate because of the cost of it and because of the lack of available reproductive material. And so we're doing the patient a benefit. How that would have come out in the case, I think, is unknown. But again, there's not a great, I think, criminal offense that meets this. And from a civil lawsuit standard, you really are looking at probably, and there are probably attorneys who are much more brilliant than I am who would be able to say exactly what maybe you could sue for. But we wanted to make sure, and there are pieces of this bill that allow for that civil liability because we wanted to make sure that that existed. But it just felt like there wasn't anything that really fits this appropriately, and so that's why this bill is here.
Okay, just one quick follow-up. So and I don't necessarily expect you to know this, so don't feel any particular way if you don't, but do you know if there was any understanding of whose sperm these women were going to be inseminated with, right? So was there ever some representation of, I will be using the sperm from the sperm bank that you contracted with, and then there was a bait and switch, I guess, for better lack of a term? Or was it just not fully ever disclosed or understood, right, when consenting to the IVF, what you were consenting, which, maybe there was no specific, we're going to use this particular sperm, but you are consenting to the procedure. Any idea?
Thank you, Senator Harris. Saha Salahi for the record. So great question. From my understanding, and like you mentioned, I'm not super sort of well-versed in this to know which it was, but I feel like it was a little bit of both. So the way it was described in this specific case is that when it came to consent, they more so just said, we are now signing the waiver for consent in regards to, okay, now we are going to get a donation, if that makes sense. It was more wide and vast. That's why they were able to go in the back and then just get that donation through his own means to make it as easy and as cost affordable than going through waiting, the long wait time that comes with fertility, and also the cost for their clinic to make the process and the treatment happen.
Thank you so much, Madam Chair. And I would just say that if you're up for consideration, I would like possibly to see some requirement that there be a disclosure as to where the sperm donation is coming in with any consent given for these types of treatments. That should possibly also help.
And thank you, Senator Harris. Nicole Cannizzaro, Senate District 6. I think that's a smart idea, and be happy to talk about that. I know that for the most part there's a lot of there's a lot of paperwork and a lot of consent that has to come along with any of these processes, and so I think just to clarify that piece of it and ensure that that's part of the bill, so that we aren't capturing anything that isn't intended to be got at with this bill, would be something we'd be very open to.
I think Senator Nguyen has a question. Go ahead.
I have a question. Unfortunately, I probably know the answer. This isn't probably the first time this has happened, although it is highlighted by a case that is very public here in Nevada. And I'm not necessarily opposed to like its inclusion in the sexual offense section. That is there research out there? Is there something out there that like ties this kind of like criminal intention to like some sort of that would place it in this sexual offense?
Nicole Cannizzaro, Senate District 6. So I am not sure if there's a specific, like a study or something. I would not be surprised if there were. I think in several states they have put it in and characterized it as a sex offense that comes along with some of the things. And I would say my own, I guess, understanding of what we're trying to get at here, there are a lot of similarities, right? It feels very much like a sexual assault type crime for those reasons. And so that's why we wanted to include it in that. But we will do some follow-up and get you any information that we find.
Other questions from members of the committee? Senator Stone.
Thank you, Senator, for bringing this bill forward. It's really important. Not only has this happened in certainly Nevada, but it's happened in many other states as well. I just want to make sure I understand what I guess I consider statute of limitations as far as filing a civil lawsuit. The 3 years starts when the person finds out that the child is not the father's or the mother's. Is that correct? It's not from the date of conception.
Thank you, Senator Stone, for the question. Nicole Cannizzaro, Senate District 6. So I do believe that is correct, and I am just looking for the language that
I think it's in
supports that.
7D,
Yep.
2D.
Yes, and I would also point to Section 7, subsection 3F as well. This is an action pursuant to Section 8 of this Act, but the cause of action shall be deemed to accrue upon the discovery by the aggrieved party of the facts constituting fertility fraud. And so that is correct in terms of your understanding of the statute of limitations.
Thank you. And then I also assume in Section 7, number 3, or that's what I just talked about, I'm sorry, Section 8, number 3, actual damages. I would assume that would also, if necessary, take into consideration the cost of rearing the child and raising the child. Is that considered part of those damages? If it's found late, let's say if the kid's 14 years old, they find out.
Thank you for the question, Senator Stone. Nicole Cannizzaro, Senate District 6. So actual damages would be anything that they may have paid in exchange for the acts that sort of then constitute the fertility fraud, would be my understanding. Whether a court would award damages in regards to the child rearing, I don't know if a court would ultimately award those in terms of actual damages, but I think there's definitely a place where you could make that claim.
Well,
typically actual damages are anything that is directly related to whatever that particular offense is or that particular action that you are suing over.
Great, thank you. I have some family members that unfortunately have had fertility issues. These treatments are very, very expensive, as you probably know, and they're emotionally really vulnerable. I have a cousin that's been trying. I think she's going for her third attempt now, and I think she's got like 2 eggs left, and that's going to be it. So these are really vulnerable people. They're spending a lot of money, and what a betrayal of trust. And I'm so glad that you brought this forward, because I think it's an outrageous crime. It's hard for me to believe it's not even a crime today, but I'm very happy that you're bringing it forward to make it a crime. So thank you very much.
No, thank you, Senator Stone. Nicole Canizaro, Senate District 6. And I think you've touched on one of the reasons why we wanted to make sure that there were some other penalties on the civil side of this. These treatments can cost anywhere from $10,000 to hundreds of thousands of dollars that people are not only saving for, taking out second mortgages on houses, just to try to have a family where they can't do that for whatever the reason is. And they can take years of time. And I think that's why when we have been discussing this with the folks who sort of brought this to my desk, that's why this is so important, because you really are taking advantage of someone who is in a very precarious position. There's not another option, right? This wasn't something they're like, oh, let me just go ahead and go through with this treatment. They can be very painful. They take lots of time. There's lots of different pieces of it that some you have to do at home, some you have to travel for, some you have to go into the office for. It can be extremely costly and extremely time consuming. And so, just to give that extra assurance and to make sure that we can hold people accountable if they abuse that, I think is important.
Other questions from members of the committee? I have 2 questions. The first one is that I want to make sure I'm understanding the pieces with the notification of the Attorney General's office and the Board of Licensing. This is the piece that would ensure that as people are looking for a fertility doctor or looking for a clinic, there is some public-facing information about anybody who has been convicted, or I guess anybody who's been convicted of fertility fraud. Is that correct?
Thank you, Madam Chair. Nicole Canizaro, Senate District 6. That is correct. We want to be able to make sure that if someone is convicted of this offense, that there are very clear messages to the public that this is someone who has done this, because that's something that as a patient you should know and be able to make informed decisions about, and we want those licensing boards to know. I think one of the things, and if Saha wanted to add to that at all, I know one of the things that we've all discussed as part of this bill was that the doctor who had been doing this, even once it had become known, there were no repercussions from a medical standpoint. And so this just continue ad infinitum without any sort of notice to patients who might not know that they're walking into that particular circumstance. And especially when it comes to fertility, because there are so few healthcare providers that work in this space, there should be good information being presented to patients in that regard.
My other question is about the term fertility fraud. It seems to me like we're using fraud in more of the colloquial sense than the legal sense of the term. And so I want to make sure that we're making our record clear that the point here is not to say that any type of fraud that occurs in a fertility setting falls under this statute, but only the specific acts laid out here. And so, I'll just give an example. So we're not talking about, young men who donate their sperm and say that they are graduates of UNLV when they're actually graduates of UNR, but we're talking about the healthcare providers.
Thank you, Madam Chair. Nicole Canizaro, Senate District 6. You are correct. Obviously, trying to describe this in a term of art that would have some delineation of what exactly it is that we're getting at, something like robbery, burglary, even though those two things I think often are used interchangeably and have different elements and are different crimes. We're really looking for what would you call this? And I think the fraud piece comes from the fact that there is an understanding of the treatment that you are getting as a patient, or as a donor, what you are donating to or for, and then that not being the case and having some very serious emotional and certainly physical consequences. And I would note that in the sections that discuss this as a crime, specifically in Section 5, you can see that it does address a provider of health care. And then in Section 6, these are individuals who are in a position to convey to a patient certain false information. And so it would be those individuals who are involved with these types of treatments, not necessarily someone who, steals money from a fertility clinic or says that, they have naturally green eyes, but maybe they're blue. And certainly those sorts of things exist. How much those fall in the criminal category, I think, is a different conversation. What we are trying to get at this particular bill is when you go in for a treatment, if you're consenting to a particular treatment, that is what you're getting. And someone who seeks to abuse that process to further their own, as I mentioned before, sort of narcissistic or egotistical perspectives should be held accountable.
All right, thank you. I don't see any other questions, so we will move to testimony in support of SB 309. Anybody wishing to give support testimony in person is invited to the tables at the front in Carson City or Las Vegas. Looks like we have some people in Carson City, so we'll start up here whenever you're ready.
Good afternoon, Chair, Vice Chair, and members of the committee. Jennifer Noble on behalf of the Nevada District Attorneys Association. We support this piece of legislation, and we thank the Majority Leader and Ms. Salahi for working to ensure that if and when a physician violates their patient in this manner again, in Nevada, we have clear laws criminalizing that conduct, which is a despicable breach of a patient's trust and their bodily autonomy. Thank you.
Thank you for your testimony. I don't see anybody coming to the table in Las Vegas, so we will go to the phones for testimony in support of SB 309.
If you would like to testify in support of SB 309, please press star 9 to take your place in the queue.
Good afternoon. This is Anna Binder for the record. I'm in support of AB 309, but I think the term you guys are all searching for is what is known to some of us as reproductive coercion. And it takes many vessels. And maybe in the future we could talk about the domestic side of criminalizing this, because it is kind of a pandemic out in the domestic violence world. But I believe that's the proper term. I don't think it was broad. It's basically coercion. You're taking certain choices away from those that are seeking those services. But full support. Thank you.
There are no further calls to testify in support.
All right, then we will go to testimony in opposition to SB 309. Anybody wishing to give opposition testimony in person is invited to the tables in Las Vegas and Carson City. Not seeing anybody, we will go to the phones.
If you would like to testify in opposition of SB 309, please press star 9 to take your place in the queue.
Hello?
We can hear you. Go ahead.
This is Susan Proffitt. Proffitt, and I'm the Vice President of the Nevada Republican Club, but I'm speaking on behalf of myself today when I say I oppose this bill, SB 309, fertility fraud. That title is kind of a misnomer. But really, the reason I do not back it is we already have laws covering medical malpractice, and I oppose it because I have a problem with bills that are overly litigious, as this bill appears to be. We do not need additional regulations because there are already 233 documents that address fraud and 840 statutes. We already have medical malpractice, and that's sufficient to cover the occasional fertility fraud issues, and the cost involved is unwarranted and ill-advised. So do not add additional financial burdens and litigious litigation opportunities on behalf of your constituents to make a political point. I really don't think we need this additional expense at this time. Thank you.
There are no further calls in opposition.
All right, we will go to testimony in neutral then. Anybody wishing to give neutral testimony in person here or in Las Vegas is invited to the table, but not seeing anybody, we will go to the phones for neutral testimony.
If you would like to testify in neutral for SB 309, please press star 9 to take your place in the queue. We have 0 calls to testify in neutral.
All right, then that brings us to the conclusion of testimony. Do you want to make any closing remarks? Go ahead.
Thank you, Chair Scheibel. Saha Salahi for the record. I wanted to answer Senator Wynn's question really quick. I believe you had a question on sexual offense in other states, examples. So I wanted to quickly clarify that. So Indiana and Texas are known to be the 2 states that have the harshest criminalization against fertility fraud. It's known that in Texas, you're able to be found guilty of sexual assault and face a felony charge in the 2nd degree, and that's similar in Indiana as well. So just wanted to clarify that. Thank you.
Thank you. And that brings us to the conclusion of our hearing on SB 309. I will now close that hearing and open the hearing on SB 367.
Thank you, Madam Chair, and thank you for the committee's indulgence. I had to go check on a tiny human who is taking a nap, so we're all good. I appreciate it, though. Thank you, Madam Chair and members of the committee. Again, for the record, my name is Nicole Cannizzaro, and I represent Senate District 6 in the northwest portion of the Las Vegas Valley. I am pleased to be here today to bring before you my second bill of the day, Senate Bill 367, which makes 3 separate changes to Nevada law related to firearms. These 3 separate changes are in the areas of 1, the possession or use of a firearm during the commission of certain drug trafficking crimes. 2, the way Nevada law treats the prohibition on a convicted felon being in possession of 1 or more weapons. And 3, the ability of a gun seller to conduct an accurate background check in compliance with federal law when a person less than 21 years of age seeks to purchase a firearm. The reason for this bill coming forward, Madam Chair and members of the committee, is sort of 3 separate reasons, but sort of all fit together in a way that presents them to you in the version of Senate Bill 367 that you see before you. Members of the committee should have received a copy of a court case that I hope you've received as an exhibit that we sent over today from the Nevada Supreme Court. That deals with the 2nd section of the bill, and so I'll take that one first. Currently in Nevada, there are a host of statutes that would determines someone to be a prohibited person in possession of a firearm. And what that generally is someone who is a felon or someone who may have a domestic violence conviction that would qualify. And I believe that there's even other legislation that's being considered potentially this session, where if you're convicted of a hate crime and could not possess a firearm as a result of that conviction, that you would not be permitted to have a firearm as a result of. So I want to be very clear that when we're talking about this, we are talking about individuals who have already had a determination made and have been put on notice and are aware that they are not someone who is permitted to be in the possession of a firearm. What occurred in that case was that an individual had shot at someone, was later tracked down and found to have in their possession. He was found to have 5 different guns in his possession. He was already a convicted felon, so he was a prohibited person, was aware he was not to possess any firearms, and yet had 5 separate firearms in his possession. When it was challenged on appeal, one of the arguments that was made was that the statute that prohibits an individual from possessing said firearm is unclear as to whether it is 1 charge or 5 charges. 1 charge for each gun or just 1 charge in general. The Supreme Court looked over the language of the statute. And that court case, again, is also State versus 4th Judicial District Court. I just realized that I actually hadn't said that out loud. So the court looked over the statute, NRS 202.360, and found that the language contained in that statute was ambiguous as it relates to the term firearms. And so despite the fact that up until 2021, it had more or less been treated in criminal courts, if you had 5 guns, you had 5 charges for each gun because you were prohibited from possessing each and every one of those firearms. When this court case made its way to the Nevada Supreme Court, they said, well, that's an interesting argument. Let's look at the statute. And the statute was ambiguous as to the term firearms. They compared it to some other statutes, and after making a decision that it was ambiguous, applied the rule of lenity, which is a common way for courts to resolve things if a statute is found to be vague or ambiguous. A court will apply certain rules in order to determine what exactly that statute is to mean. So in applying the rule of lenity, that benefit inures to the accused. And so the court found in favor of the defendant and said, well, since the statute is ambiguous, we apply the rule of lenity and therefore find that this statute meant to apply to any possession of any firearm, which would be a fine interpretation if we weren't also talking about the fact that this now gives a loophole to individuals who are prohibited from possessing firearms, which there have been policy decisions made, not only by this body, but by the courts, to say that certain individuals cannot possess a firearm. When you cannot possess a firearm, there is a huge difference between having 1 firearm, which happens, or 2 firearms, and having 10, 50 firearms. There is a loophole that incentivizes the stockpiling of weapons, specifically firearms, for individuals who are aware that they are not to have one. And I think that one of the things about this particular bill is that we want to make sure that if you are someone who is prohibited from having a firearm, that means you're prohibited from having 1, you're prohibited from having 2, you're prohibited from having 10 or 50. If we are to give full force and effect to that, I believe that we should charge each individual handgun or firearm or assault rifle or whatever the case might be as a separate charge, because that individual is just as prohibited from possessing 1 as they are 10 or 50. And what we should not do is have a statute that incentivizes individuals who are prohibited persons from finding additional firearms, because there is no consequence to that. There is no difference if you have 50 guns or 100 guns than if you have 1. There is no difference if you have 5 firearms or you have 1. So why not have 5? And that is an incentive that I do not think meets the intent of why it is that there are certain individuals, either because of their dangerousness or because of their record or because of whatever the policy reason that we have already determined, should not be possessing firearms and is already a prohibited person. I also want to make that point as well, that this is not deeming new individuals to be prohibited from possessing firearms. It is not making new rules about what is expected if an individual has a prior conviction. These are individuals who are already, they have been convicted of a particular crime, and they are already prohibited from possessing those firearms. If we cannot say to people who are trafficking in guns, to gang members who are stockpiling them and trying to sell them on the streets, that there is not a difference there, that to me doesn't meet the intent of NRS 202.360 and doesn't meet the intent of what we should or how we should be handling individuals who want to have multiple firearms, who are not to have multiple firearms. So that's the second piece of the bill. The first piece of the bill, Madam Chair and members of the committee, is a state statute that is offered to mirror what currently exists under federal law. One of the things that exists under federal law is that if you use a firearm in the course of certain trafficking offenses, so to be clear, this is not an offense where someone is in mere possession for possession of a controlled substance. Is if you have some cocaine or some heroin, you're a drug user, you have those kinds of charges. That's not what this would pertain to. These statutes that are listed in Senate Bill 367 in Section 2 relate to the offer, manufacture, transport, to trafficking in a controlled substance, to possession with the intent to sell, and to conspiracy to violate the Uniform Controlled Substance Act. These are all acts that are not mere possession. Obviously, trafficking is a possession-based crime, but as the trafficking laws exist now, are very high thresholds that someone who has that amount of threshold for those trafficking offenses is doing much more than just a simple user who has it for personal use. So I think that that's an important point to make, because we're not trying to just criminalize individuals who might have a drug addiction. That is something that this body has discussed at length. But what we have seen, and what certainly the Metropolitan Police Department in Clark County has seen, is that there are situations where individuals are engaged in the selling, the trafficking, the transport, the manufacturing of controlled substances, and are using firearms in the commission of those crimes. And when firearms are used in the commission of those crimes, it currently is not a crime. But that is a much more dangerous situation that presents itself with a much higher likelihood of injury when you are using a firearm in order to complete a drug deal. And someone who is using a firearm to do that should be held accountable. So this mirrors what currently exists in federal statute. There is a federal statute on the books currently that allows for an additional enhancement. It is 18 USC 924C if you use a firearm during and within the commission of one of those types of offenses. And so the first part of this bill does the same. And so in Section 2, you can see that if they use a firearm in the furtherance of the commission of any of those offenses, that this would be an additional charge. It is a Category B felony and from 1 to 6 years. So that is, and the reason for that, I believe, is because of the dangerousness that exists when you are using a firearm in order to commit those particular crimes. There is a third piece of this bill that relates to the dissemination of information related to background checks, and I'm happy to be joined by Bridget Duffy, who can walk through that in a little bit more detail, Madam Chair. If it is okay with you, and I know I sort of got into some of the details of the bill, but I would like to just briefly walk through the sections of the bill and then turn it over to Ms. Duffy to walk through the pieces, or not to walk through the pieces, but to have her with me here to answer some questions as it may pertain to the background check information and some cleanup language that is proposed as sort of the third piece of this bill. So in terms of a bill summary and walkthrough, you will see again that mirroring federal law, Section 2 provides that a person who possesses or uses a gun during the commission of or in furtherance of a drug trafficking crime in violation of Chapter 453 of the NRS is guilty of a Category B felony. This violation is in addition to any other violation committed as part of that particular crime. Section 3 of the bill responds to that Nevada Supreme Court decision that I mentioned that says basically no matter how many weapons or how much ammunition that you may have in your possession when you're arrested, the law is only allowing that person to be charged with one count of a felon in possession of a firearm or a prohibited person in possession of a firearm. This bill instead clarifies that language with how the statute has historically been used. And I actually have to give a huge shout out, because one of the things in the court case was that there hadn't been any actual legislative intent submitted to the court, although that was argued by the state. And so I did reach out to our very fantastic research team and Mr. Guinan, who is brilliant, and discovered that this statute has been part of Nevada law since 1925. So there is just not legislative history that exists in a fashion for us to be able to cite to this committee, but since then has been used in the fashion that is proposed in 367 up until that Nevada Supreme Court case. But this bill would provide and would clarify that language that the Nevada Supreme Court found to be ambiguous, that each dangerous weapon owned, possessed, manufactured, sold, disposed of, handled, used, or carried by, or otherwise under the custody or control of a prohibited person constitutes a separate violation of the law. And then finally, sections 5 through 8 address gun purchases by persons 21 years of age and are intended, again, to bring Nevada in line with federal law. These sections allow the courts, juvenile justice agencies, and child welfare agencies to share a minor's confidential records with a federal, state, or local governmental entity that needs to access those records in order to conduct a background check, as is required by the federal Bipartisan Safer Communities Act that was passed in 2022. And as I mentioned, Ms. Duffy probably can answer more questions on that piece of it. I do also believe that we had received an amendment, and you may hear about this with respect to the background check information items from Clark County that does appear to be fairly amenable and would make some changes to those portions of the statute. So we're happy to answer any questions of that. But if you hear of that amendment, that's something that we are considering, and we think it makes some good changes. So with that, Madam Chair, we'll stand open for questions from you or members of the committee.
All right, thank you. Committee, do you have any questions? All right, Senator Hansen.
Thank you, Madam Chair. My question is on the juvenile part. We've been working kind of hard to protect juveniles to a certain extent. You make a mistake when you're under 18, and those, ideally, we don't want those to follow them into the adult world. So I'm really kind of disturbed about the Section 6D, regardless of whether or not they have been sealed. One of the purposes of sealing those records is to help protect people from having that criminal cloud hanging over their head going forward. Why are we changing that in this particular case?
Bridget Duffy for the record. Thank you, Senator Hansen, for that question. So sections 5 through 8, all of them are in response to that Bipartisan Safer Communities Act passed in 2022. As you know, in Nevada, it is legal at the age of 18 to purchase a rifle, and those rifles also include AR-15s and semi-automatic rifles. And so looking at some of the mass casualty attacks we've had by young adults at age 18, Parkland shooter was 18 when he legally purchased a firearm, the AR-15 that he used to shoot up his school. The Robb Elementary shooter in Uvalde, Texas, purchased his rifle on his 18th birthday or a day after. The Buffalo supermarket shooter was 18, and he cleared a background check, and he had a history of mental health and threats to his school. So when the federal law requires that we go back only to ages 16 and 17, but because we've sealed juvenile records, I could walk in at age 18, and you would have no idea that the day before I was released from a mental hospital, or the day before I had just gotten off probation for a violent offense. But if I'm 40 and I walk in, you will know all of my history, and it would exclude me. So it's really, in my opinion, not about keeping guns away from 18 to 21-year-olds. That this bill does not change that. It just extends that background check to make sure that we catch what would happen if an 18-year-old walked in that is still potentially a senior in high school, because you can be in high school until you're 21, and is able to legally purchase that firearm. So it gives a better background check to ensure they have the best information available.
Okay, well, I don't know. It just bothers me that if there are already mental health issues and things like that, or are you saying that their records were sealed and the people who, when he went in at 18 to try to find out if he had one, were not able to locate that? In Uvalde, Texas, wherever it was you just mentioned?
Bridget Duffy, for the record. I do not know that what would have been caught in Buffalo, New York for the individual that I had found had some background, like through studying these 3 shootings by 18-year-olds. So I don't know ultimately if it would make a difference, but to me, it's not responsible if we have that information somewhere and we don't know. And that child can walk, that young adult who has an undeveloped brain, who's still in senior in high school, could legally purchase a firearm and walk into a school. And
course.
maybe we have that history somewhere that they should know.
Of course, the development of the brain, we know, goes to 25 now. So the idea that, when you're 18, you should give up. So my problem is that they're sealed records that you can go back and get into. Why would they be sealed if the individual has mental health issues in the first place?
Bridget Duffy, for the record. So the sealed records are the juvenile delinquency history, which was Senator Krasner's bill from last session. We changed the juvenile records used to automatically seal at 21. And so all of these things would have been able to be caught. But last session, we changed it to 18 for most offenses. And so now they're automatically sealing at 18, so they're not catching them till 21 anymore. And this law passed in 2022, the federal act passed in 2022. So it allows, and it's only for offenses that were committed at age 16 and 17. It's not your entire juvenile history, and it's only limited to those same offenses that they would be looking at if you were an adult trying to purchase a firearm. It's not every petty larceny or marijuana joint that you had. It's only those same offenses that they look for when a 40-year-old walks in to purchase a firearm, and only limited to ages 16 and 17. And then the mental health history, so that goes into the child welfare, into the child welfare records, into foster children. So in NRS 433A, which is our mental health statute, anybody that is involuntarily committed by court order to a mental hospital, those records, that court order is automatically sent to the central repository for background checks. So if a child out in the community is involuntarily committed, they'll catch that. Age 16 and 17, we're not talking younger than that. But we have a whole system of children in foster care that can go through a process in front of a court to be committed into a mental institution for issues. So that Section 8 ultimately allows those records, that court order, to be transmitted to the central repository when the court orders that child in. But without this bill, people don't even know that happens, like that there's a whole system in there.
Okay, I'm confused on that part then. So mental health records are included right now. They're sealed. So if you're 19 and you go in to buy an AR-15, example you gave, but I have clear mental health issues that have been charted in my 16th, 17th, 18th year, those things right now, if in the absence of the passage of this bill, would be sealed?
Bridget Duffy, for the record. So they're not sealed, they're confidential, except if it's an involuntary commitment. So if you are involuntary committed, which is what the Federal Bipartisan Act requires, a court-ordered admission, not I just walk in and seek mental health treatment. It's a court-ordered admission. So out in the community, if I am involuntarily committed by court order, so I'm 16, 17, 18 years old, that information is sent over to the central repository. However, we have a group of children, 16 and 17, who are in our foster care system, who may need residential treatment facilities, who then go through a whole court process, including second opinions, they have lawyers, they get trials, and then the court says, yes, you need to go to a residential treatment facility. That information is confidential, and I can't turn that over to anybody without this bill.
Okay. I'm still a little confused, but thank you very much for that explanation.
All right, other questions from Senator Wynn?
I have a question. Do you know how other states have similar statutes for possession of a firearm by a prohibited person? Do you know if other jurisdictions, like, are there trends on whether or not they are treated as individual offenses and they're stacked, or I don't know if you know that information, but if you do, that's my question.
Thank you, Senator Wynn, for the question. Nicole Canizaro, Senate District 6. I do not have that information, but would be happy to get some of that for you. Again, I think this sort of stems from how a statute had been interpreted up until 2 years ago, and then changed because there was there was found to be an ambiguity. And really, even aside from the ambiguity piece of it, what the bill is designed to do here is to ensure that there is not some loophole or incentive for individuals to have multiple weapons when they're not entitled to really possess even one. And so we will definitely work on getting you that information on how some other jurisdictions are treating it.
Other questions from members of the committee? Senator Krasner.
Thank you, Chair. Thank you for your presentation. So, Ms. Duffy, I have a question. It kind of relates to my colleague's question. So let's say a 17-year-old high school student has been bullied mercilessly because they're gay or trans, and they feel so angry and, maybe suicidal or depression, and they go talk to the school counselor or another counselor. Now is that person, then they get older and they see, they have help or whatever. They get help from a counselor to understand better. Is that person now going to be a person that's on this list and their records are going to be made public just because they were bullied and they did the right thing and went and saw a counselor and sought therapy and told the truth about their feelings toward those people that were bullying them? Would they be included in this?
Bridget Duffy, for the record, thank you for allowing me to clarify. That's a really great question. The answer is no. I would venture to guess in today's climate, we have thousands of children who seek counseling, outpatient counseling. They need help. This bill would impact court-ordered admissions to residential treatment facilities. So a child a psychologist or a psychiatrist has made the recommendation that this child needs inpatient mental health treatment. In Clark County, that average is about 8 a year, where this bill would impact a court order being transmitted over to the central repository. But I would venture to guess thousands of children nobody is going to know their personal information. But those that are court ordered, that is what this will impact.
All right, other questions from members of the committee? Not seeing any, we will move to testimony in support of SB 367. Anybody wishing to give support testimony in person in Las Vegas or Carson City is invited to the table now.
Good afternoon, Chair Scheibel and members of the committee. My name is Director Beth Schmidt. I'm representing the Las Vegas Metropolitan Police Department. We want to thank Senator Canizaro for sponsoring SB 367. We support this bill because it will align Nevada statute with federal law and treat drug dealers with firearms the same as felons in possession of a firearm. This bill will also establish that each firearm owned by a prohibited person constitutes a separate violation for purposes of unit of prosecution. We believe these changes will have a positive impact on our community by curbing the violence associated with illegal narcotics trade and act as a deterrent for suspects involved in the illegal narcotics trade to be armed. In LVMPD's jurisdiction, we have seen a steady number of firearms and violence associated with illegal narcotics sales. Since 2021, the Las Vegas Metropolitan Police Department's narcotics section has made 145 narcotics-related arrests that involve firearms. In these arrests, 593 firearms were seized along with narcotics. That's an average of 4.09 firearms per arrest. During this same time period, the LVMPD narcotics section has arrested 33 prohibited persons in possession of multiple firearms while engaged in illegal narcotic sales. LVMPD supports SB 367.
Thank you, Chair Scheibel, members of the Senate Judiciary Committee. My name is John Jones, and I'm here on behalf of the Nevada District Attorneys Association in support of SB 367. And I'd like to thank the Majority Leader for bringing the bill. It's our position that we do not want to encourage those who are prohibited from possessing firearms to, quote, go big. And the unit of prosecution for these types of offenses should be for each firearm possessed. And we are strongly in support of efforts to do that. With respect to the sections of the bill that prohibit the possession of firearms while engaged in trafficking level offenses and the sections that put us in compliance with the federal Safer Communities Act, we are also in support of those. Thank you, Chair.
Before you escape, Senator Hansen does have a question for you.
Thank you, Madam Chair. Okay, the go big concept. Are you telling me right now that when you go and you prosecute a drug dealer and they have a single firearm or they have 500 firearms, the judge doesn't make any distinguishment in punishment?
John Jones on behalf of the Nevada District Attorneys Association. If they're not a prohibited person, then they would not be charged with the firearm as under current law. If they are a prohibited person, then they would be charged for one count, no matter how many firearms they had. So I believe the Metro indicated that they're averaging almost 5 firearms in their trafficking level offenses. So there would be one count in those situations, and we're arguing that it should be at least 4.
Okay, I got it. But as far as the count, when it comes to actual punishment by the judge upon conviction, they're not allowed to take into account that this guy, number one, wasn't supposed to have any firearms, and on average he had 5. I have a hard time believing a judge is going to say, well, we're going to ignore that when it comes to the punishment side.
John Jones on behalf of the Nevada District Attorneys Association. So you're saying that that could be used to enhance the trafficking level offense that they're in front of the judge for. Potentially a judge could consider that, but they're not getting any extra punishment on top of the mandatory minimum or maximum that they're facing for the drug charge. In this instance, there would be extra punishment for the firearm specifically.
Okay. Thanks, Madam Chair.
Good afternoon, Chair Scheibel, members of the committee. Jason Walker, Washington County Sheriff's Office, testifying in support of Senate Bill 367. I believe it's a good bill on all its parts. More often, we are encountering drug traffickers with guns as well as persons prohibited being in possession of multiple firearms. Moving this bill forward enhances our legal teeth to hopefully get a better grasp on these offenses.
Thank you, Madam Chair, members of the committee. For the record, Mike Cathcart, representing the City of Henderson. We're in agreement with the previous speakers. We're in support of Senate Bill 367 and believe this is good public safety policy. Thank you.
All right, that looks like everybody in Carson City. I don't see anybody coming to the table in Las Vegas, so we will go to the phones for testimony in support of SB 367.
If you would like to testify in support of SB 367, please press star 9 to take your place in the queue.
Good afternoon, Chair Scheibel and members of the Senate Judiciary. For the record, this is Pamela Del Porto, EAM, Del Porto, DEAO. I'm the Executive Director for Nevada Sheriffs and Chiefs Association. We would like to thank Senator Canizero for bringing this bill forward. We are in strong support of 367. Thank you so much.
We have no remaining callers to testify in support.
All right, then. We will come back to in-person testimony in opposition to SB 367. Anybody wishing to give opposition testimony in Carson City or Las Vegas is invited to the table. Go ahead whenever you're ready.
Good afternoon, Chair, members of the committee. Erica Roth, ERICAROTH, on behalf of the Washoe County Public Defender's Office. Testifying in opposition this afternoon, I do want to first thank the Majority Leader for speaking with my colleague, Mr. Pirro, and I regarding some of our concerns, and we look forward to furthering those conversations. I'm going to touch briefly on the first section, Section 1 or Section 2 in the bill, and my colleague, Mr. Pirro, will touch on Section 3. We understand the policy directive, right, when we're thinking about mirroring the federal statute. What I don't want to be lost is that when we're looking to 18 USC Section 924C, which is the federal statute that this is mirroring, in 2018, former President Trump passed the First Step Act, which addressed what is called and what the federal sentencing, the U.S. Sentencing Commission has termed stacking of charges, which is what happens, and they've directly referenced 18 USC Section 924C. The First Step Act in 2019 said we need to readdress how we're sentencing and stacking charges for multiple offenses, or in this case, it would be somebody is trafficking or alleged to be trafficking in drugs. Now we can stack on 1, 2, 3 additional firearm offenses to that. It can force plea deals and deter people from going to trial. So in 2018, the federal government said that this practice is not ideal, and we want to take a step back from that. And in just January of this year, 2023, the U.S. Sentencing Commission reaffirmed that notion in their proposed rules that were issued in just January, again reaffirming what was put forth by former President Trump in the STEP Act. And so this is our concern. We don't want to mirror the federal statute if from a policy perspective, the general consensus is that we should be moving away from that practice. That's where our concern lies, and ensuring that everyone is given a fair trial, the opportunity for a fair trial, and not basing those practices on something that we are now understanding can be very detrimental to the system as a whole. So that's where I'll end. I appreciate the amount of time I've taken, and Mr. Pirro will address the second part of the statute. Thank you.
Thank you, Chair. John Pirro from the Clark County Public Defender's Office. A couple things. With the incentivizes talk that the district attorney used, I've never heard a client say, you know what, I watched those hearings on the legislative thing, and this penalty is not steep enough, and I'm definitely going to do this crime more often. Now, maybe we should pipe these hearings into the Nevada Department of Corrections, but we do not currently do so. But the Nevada Independent has also published a little fact check that's saying raising penalties does not deter crime. What does, though, is when you catch people faster, and it's immediacy of punishment, not necessarily stacking it up. The case that's referenced here, the State versus 4th Judicial Circuit, when they tried this gentleman, they got 10 felony convictions instead of 15. They had to give up 5. And that gentleman is currently sitting in the Nevada Department of Corrections for 28 to 70 years. So there's no loss of harsh sentencings when offensive crimes occur. Couple things with the stacking of charges. Yes, it will definitely incentivize plea deals rather than taking a case to trial and fighting it. And then there's some statutes in here that most of them make a lot of sense, but some portions of the statutes, like NRS 202.257, that prohibits being under the influence of alcohol and possessing a firearm. Now, that person who's under the influence of alcohol and possesses a firearm, if he owns multiple firearms at the house, will have many firearm charges stacked against him. If he owns a lot of firearms, he's a legal firearm owner, but he commits that crime, then we're just going to stack him up. So that's our concern with the stacking, and we hope that we can work out a resolution with the majority leader and move this bill forward. Thank you.
It looks like we have another question. Senator Hansen, go ahead.
Thanks, Madam Chair. The ticket stacking issue, that's been a huge one around here for a long time. And consequently, for public defenders especially, if you're wealthy enough to hire a full-blown attorney, you can work a very reasonable plea bargain out typically with the prosecutors. The issue you just raised is a super red flag for me, because the poorer people that have the most difficult times have to turn to you guys. Yet when there's the ticket stacking problem, when you do a plea bargain negotiation, typically, don't you guys, like you just said, 15 down to 10, but you still have 10 that this guy's going to get sentenced on, and that limits your ability. Now, if he had been charged with 5, maybe you could have got it down to 3, and the guy would serve 20 years instead of 27 to 70 or whatever you mentioned. So I'm just kind of wondering, the more we pass laws like this, especially for indigent, poor, minority community people who are frankly disproportionate when it comes to some of the drug issues and the guys that they're catching, aren't these guys often, ladies too I should say, aren't these often the ones that need frankly your services the most, and who will be hurt the most if you have this constant ticket stacking, which really prevents your ability to make reasonable plea bargain arrangements?
John Pierre for the record. 85% of the people charged with a crime cannot afford a lawyer, so we do represent the majority of those, for sure. And when it comes to charge stacking, yes, it greatly limits our, I would say, the willingness of a client to take a case to trial and fight it, and the ability to negotiate to what we would deem a reasonable settlement.
Yeah, and when I look at this bill, you could get a felony charge for every metal penetrating bullet. You could have, if some guy has 25 bullets in his arsenal or whatever they want to call it, technically could they not have 25 separate citations for a felony conviction that you now have to plea bargain against, rather than just 1 for weapons or 2 for different weapons or something like that?
John Pierre for the record. You are correct, Senator. That would be 25 1 to 6 year penalties that person would be facing. And the question you referenced to Mr. Jones as well, the judge could and should take all of that into account when sentencing somebody, even if they're not charged with 25 separate counts.
All right, that's what I understood too. I mean, we seem to be missing the fact that judges are part of this process as well, and they're supposed to come up with reasonable punishments. Yet when you stack the deck so strongly against especially a poor defendant who has 2 years of services, the odds are greater that they are going to receive excessive levels of punishment than somebody that can hire a first-class criminal defense attorney. Thank you, Madam Chair.
All right. I don't see anybody coming to the table in Las Vegas, so we'll go to the phone for testimony in opposition to SB 367.
If you would like to testify in opposition to SB 367, please press star 9 to take place in the queue. Chair, they're unmuted. I don't think they're unmuting themselves.
All right, then.
Hello, I'm here.
Oh.
Hello?
Go ahead, we can hear you.
Is it my turn?
Yes.
My name is Susan Proffitt, Proffitt, and I would like you to rewrite this bill or scrap it because it's a bit ambiguous, a little bit too much. We need to stop the violent drug traffickers. But this bill, the way it's written, could open up a lot of people to malicious prosecution and for political purposes and overly penalize poor communities. A criminal can always find a way to get a gun. What the? Did you shut me off?
No, we did not.
Oh, I'm so sorry. I couldn't tell. Okay. I really think that we need to know who gets to determine who is mentally sound, and will this be addressed by clinical psychologists, and who gets to determine who's too dangerous to possess a gun. And recently, our own president labeled parents of school board meetings and Trump supporters domestic terrorists. So you must understand that we really have a problem, and we don't understand why you would bail BLM and Antifa citizens out of jail, and yet come up with a bill like this that looks like it's meant to take the guns out of law-abiding citizens' hands any way you can. And that's just not okay. It's against our civil rights. Thank you.
There are no remaining callers in opposition.
All right, then we'll go to testimony in neutral. Anybody wishing to give neutral testimony in Carson City or Las Vegas is welcome at the table now, but not seeing anybody. We will go to the phones for neutral testimony, please.
If you would like to testify in neutral for SB 367, please press star 9 to take your place in the queue. There are no remaining callers for neutral.
All right, then. Unless you have any closing, do you have any closing remarks? All right, thank you.
Thank you, Madam Chair and members of the committee, for your time this afternoon. There are a couple of things that I just wanted to highlight. So with respect to the case, and I know Mr. Bureau and I discussed this as well, to the State versus 4th Judicial District Court, he actually shot somebody, so he did get a very lengthy prison sentence, certainly probably more so than the firearms, but that's a case that this stemmed out of. And someone with 5 guns who is committing crimes and shooting people, I think should be charged for all 5 guns because they're each prohibited, which brings me to sort of my second point I wanted to address. This is not stacking. When we've talked about stacking in the course of this committee, when we talk about stacking in terms of criminal penalties, it is that you committed one act, but that one act may constitute several crimes. It might constitute a burglary and it might constitute a robbery and so when we've had discussions about stacking and sort of the policy pieces behind that, I wanted to sort of make that differentiation because this is not stacking in that you've committed one offense, but somehow it may fall or meet the criteria, the elements of several offenses such that you might be charged with multiple felony offenses for doing one thing. These are different felony offenses. If, for example, by way of hypothetical, you are a prohibited person and you have a gun in your car and you're stopped and for whatever reason they manage to search the car, they find the gun, you're a prohibited person, that is a felony because you're a prohibited person in possession of a firearm. If you also have back at your house and the next day they show up at your house for some reason and they search your house and they find a firearm, that is also a felony because you're a prohibited person in possession of a felony. Or in possession of a firearm. What this bill is seeking to do is that if you happen to be somebody who's got both those guns in your car, or 5 guns in your car, or 10 guns in your house, you are equally prohibited from possessing every single one of those guns under the law currently. And that is how this statute has been read. So this is not stacking. I think there's a differentiation. And whether this committee thinks you should be charged for each and every illegal gun that you have in your possession is the policy decision for this committee to make. That's the policy decision that exists in this bill. And I've got several reasons that we've all discussed and that I've certainly said today as to why I believe you should be charged for each one of those guns. But it's not a stacking situation. It is that you are committing multiple illegal, impermissible offenses that up until 2 years ago you would have been charged for. And I think that there is a huge difference between someone who is a felon and maybe has one gun because of whatever reason, maybe they feel as though they need it for protection. It's a very different situation than someone who has 10 guns. And we should be treating them differently. They should be treated differently under the law because it it is equally as illegal to have each and every one of those guns. The other thing that I wanted to just point out is that the people who are impacted, especially by that portion of the bill, are already prohibited. They have already been convicted, not charged, convicted of a crime that prohibits them from possessing a firearm. It is something that they are aware of, it's something they are on notice of, and they are already prohibited. So we are not, and that's, I think, the balance in this bill and why I thought it was appropriate to bring it forward, is that you're not trying to create something where now all of a sudden someone who previously had the right to possess firearms or to possess ammunition or what have you, they already cannot do that. It is already illegal. It is already something that they know they cannot have, but we should be addressing it appropriately. And on the other point, I have to say that I do think that, and I admire the job that our public defenders do. I think a lot of them are some of the best attorneys in this state, and Mr. Pirro being one of them. I have known him and practiced with him for a long time, and he's an excellent defense attorney. And so there's lots of really great defense attorneys at the public defender's office. I know that they can handle these types of cases because they have been doing so for many years. And I just think that we should treat that appropriately when someone has a litany of firearms versus one. It's a different situation. They're equally as prohibited from possessing the one as they are the 5, the 10, the 50. Thank you, Madam Chair, for the time, and appreciate you giving me the opportunity to have the bill heard.
Thank you so much for joining us today and presenting these bills. You are not done yet. We have one more to go, and I will now open up the hearing on SB 378. Please go ahead whenever you're ready.
Thank you, Madam Chair and members of the committee, again, for the third time is a charm. My name is Nicole Canizaro. I represent Senate District 6 in the northwest portion of the Vegas Valley, and I'm here today to bring to you Senate Bill 378, which revises provisions relating to common interest communities. This bill revises requirements for common interest communities when providing a website or online portal for their association, and also establishes guidelines that a homeowners association must follow if they allow unit owners to make payments electronically through their website or online portal, and allows an association in very limited circumstances to be able to purchase a unit at a foreclosure sale. I do have with me, Madam Chair, Garrett Gordon with me, who would be happy to walk through some of the pieces of the bill. And then I do also believe that we have down in Las Vegas an attorney who can help us to answer questions and walk through specific pieces of the bill. But in short order, that is what Senate Bill 378 does. And with your permission, I'd love to turn the presentation order to Mr. Gordon.
Thank you, Madam Chair. For the record, Garrett Gordon. I'm a partner at the law firm of Lewis Roca, today representing CAI. I just want to first thank the Majority Leader for sponsoring this bill. We very much appreciate it. I'll make a few comments, Madam Chair, and then turn it over to Mr. Clarkson, who's in Las Vegas, who will walk through the specifics of each section. So this bill really stems from a bill passed last session, Senate Bill 186. There were some unintended consequences as a result of that bill, so this bill is really a cleanup. Mainly speaking, the first section deals with electronic payments. Last session, we discussed and was approved the ability of associations to accept electronic payments from homeowners, right? Makes a lot of sense, an efficient process. There was concern that we heard from our association, CAI, and from some of the homeowners that if that option was available and was taken, that now the association has personal information from their homeowners, which typically they don't want, but they'll have in regards to a credit card payment or a debit payment, et cetera. So this first section really deals with making sure the association has ample insurance in order to accommodate and insure over any potential data breach now that they have a homeowner's personal information. Number two deals with electronic communications. Many homeowners, maybe some of you, rather than getting the agendas, the budgets, a lot of paper documents in your mail, can opt into hey, email that to me. Association, please email me the information and documents that you're providing. Last session, again, as a result of a really unintended consequence, the language was included that said you had to mail and send out electronic mail for some of these documents. And again, we heard from, I think the majority leader did, and many of you from some constituents saying, I do not want this mail, not only because it clogs up my mailbox, but it costs me money. Associations, every time they do a mass mailing, there's stamps and there's mailing costs, and the goal really here is to minimize that cost that gets spread out by all homeowners if in fact they utilize the electronic communication aspect. And then 3, last session, SB 186, we took some language from other states that dealt with who in fact was prohibited from buying a home at a HOA foreclosure sale, really a conflict of interest policy. That language was pulled in from many different states, and I think a very good, robust conflict of interest section in regards to that. As a result of that bill, however, there was an unintended consequence of pulling out a specific section as it relates to credit bid, in the very rare circumstance that there's no one there to bid on the property, the association ends up with the property and works with the homeowner moving forward. That language was stricken, so we're just adding that back in. So with that, Madam Chair, I'll turn it over to Mr. Clarkson, who will go a little deeper in regards to the language, and he and I will be here for any questions. And thank you for hearing this bill today. We appreciate it.
Go ahead whenever you're ready.
Thank you, Madam Chair, members of the Judiciary. I'm Adam Clarkson. I'm the chair of the Community Associations Institute Legislative Action Committee, also known as CILAC. CILAC is the voice of homeowners, homeowner associations, and other industry professionals at the legislature. So we look at these issues very closely. Also, by the way, I'm a community association law attorney. I've been practicing community association law here in Nevada since 2006. So just to go over top to bottom over the bill. First off, the changes that occurred at last session added a provision that required community associations to allow for electronic payment, which community associations, we're all for electronic payments. We're all for making things easier. We want everybody to be happy with that. However, it literally is basically that's pretty much it's like a sentence that says that. So it didn't have any information about proper data security. It didn't have information about addressing insurance for cyber theft and the other various issues that could occur where an association is dealing with an electronic payment system. So what we wanted to look at with that and what we changed, what we're proposing here is requirements for basically minimum insurance levels, a minimum level of $5 million of insurance coverage, either for the association or if the association is using a third party, like a community management company or a bank or anyone else, that they're going to have a minimum level of cybersecurity insurance to cover for the cyber theft and data security issues that may occur when you're processing payments like this, because we're dealing with people's private information, like bank information. Similarly, if association contracts out with a third party, we still want certain minimums for the association, and we set those minimums according to the size of the association. So as the associations get larger, smaller associations, we're looking at $250,000. Anything over 250 units is going to be $1 million in cyber insurance that the association itself needs to carry. That portal does have to allow them to suspend the ability to make payments in the event that it goes to a third party for collections, because of course all the collection provisions, collection laws go into effect. So that person would be needing to deal with those individuals and not be processing at the association site. This incorporates NRS 603A-010 to NRS 603A-290, which is the data security provisions that the legislature passed several years ago to protect personal information of individuals for internet sites. And then finally, it requires an association's board to make a determination under a cost-benefit analysis as to whether or not they want to have this portal, because it does cost money. They're going to have to pay for insurance. They're going to have to pay for the cost of having this service. And for some associations, that cost may exceed the benefit because it may cost a few $1,000s and it may be an association that has a very small budget, so it doesn't make any sense. And then they did a good job laying out the definitions for that. Going into Section 2, they just expand to provide that this act applies for associations that section applies to associations that are over 6 units in size. Then we move on to Section 3 of the Act, which this is largely a cleanup with respect to communications. So just to understand, NRS 116 through 1068 is a catch-all provision for communications that are required under the law. So if NRS 116 provides that an association has to make a communication, but it doesn't provide the manner of that communication, then it falls under this catch-all for how that communication is sent. So things like the annual meeting notice, the regular board meeting notice, updated budget information, those would go through this process. Items like collection items where somebody's if they're delinquent in their assessments, homeowners are still going to get certified mail for that because that's excluded from this catch-all process because there's a specific process for requiring that. And then this language, what we've done is essentially clarify that everything will go through email. So as long as the homeowner designates an email, it's going to go through that. If they haven't designated one, but are using one in communication with the association can assume that that's the correct email and send them those notices, those catch-all notices through that as long as they receive it, and as long as they're happy with it, and as long as they don't opt out. And of course, any homeowner is allowed to opt out at any time so that they don't have to follow this process. Also importantly, we eliminated some language. There was some overbroad language in it that was added that required all communications to be done in this manner, or information which just doesn't make sense because sometimes you're going to need to call somebody. Somebody left their keys at the clubhouse, and you know they left their car keys at the clubhouse, and you know whose car keys they are. You should be able to call them and let them know they left their keys. We shouldn't have a statute that dictates that you have to send an email or a letter to do that. So this just clarifies that the statute applies to legally required notices and not just every single communication that may occur at a community association. Section 4 clarifies the documents that are required at the association's portal. At last session, there was an addition that required associations to have a electronic portal for folks to go online and look at information about their community association. And it had a lot of information that was there that it was very broad. It didn't clarify exactly what was needed. And some of these associations are over 100 years old. There are bankers' boxes on bankers' boxes of documents, and we really just wanted to clarify the information that was important for homeowners to be able to get. So this clarifies that homeowners can get copies of their governing documents through the online portal. They're going to be able to get their annual budget and any proposed budgets. They're going to be able to get notices and agendas for their upcoming meetings. That way, that's going to get them the relevant information about the community association, but not put their personal information at risk, and also not have an endless question mark over what information should be there. And then finally, as mentioned by Mr. Gordon, there were provisions in the statute that was a change to track with other states in order to preclude folks that had a conflict of interest from purchasing an association foreclosure sale. CILAC's absolutely in favor of that. However, inadvertently, the provision that allowed for community associations to purchase through credit bid was eliminated in that process. That's been in the law since the laws basically began. We presume that it was an inadvertent error. We'd like to see that put back in there just for clarification in that rare circumstance. And we'd like to thank Senator Canizero for supporting this bill for us, and thank you guys for your time. Thank you.
All right, thank you very much for your in-depth presentation. There you go. And are there questions from members of the committee? Senator Stone.
Thank you for your presentation. Just want to make sure I understand a couple of things. So this is a opt-out. Otherwise, you're going to get electronic notices, except for the ones that are required to go by mail if they're going to be leaned on. Is that correct?
Go ahead, Mr. Clarkson.
Thank you, Senator. Yes, that is correct. It's an opt-out unless you, so you're automatically going to get electronic mail.
Could you put your name on the
provided
record
you've
again?
given electronic mail. I'm sorry. This is Adam Clarkson on behalf of CI LAC. Yes, it's an opt-out. So if you designate an email address, it's going to go to that designated location. If you use an email address, they'll use that email address for you. Now, of course, if you've never used an email address or designated one, they're not going to have one to utilize, so they wouldn't do that. But otherwise, it is a pure opt-out. Yes, sir.
Thank you. And then if I could just ask another question. If a HOA goes ahead and puts a website up where they have payment options in order for a homeowner to pay their homeowner association dues, is there any prohibition on charging any fees, like credit cards? Is a credit card service charge? Sometimes you might partner with a third-party place that charges $1.99 for an ACH transfer. Is that allowable?
Thank you, Senator. Adam Clarkson, CI LAC. This does not preclude that, so that would be presumably discretionary as far as a pass-through cost.
Well, thank you. Senator Cannizzaro, this is Madam Leader, I should say. I think this is a great bill from a person that owns dozens of units that are part of HOAs, and some are in the same HOA, and I get a stack every time there's a meeting of literally hundreds of dollars worth of postage every year. And I've made the request many times to them, please send it by email. I'm one owner. You don't need to send me a different notice for every HOA meeting that you're going to have. You know, at a time when people are crying because their HOA dues are going up, this is a way where you can actually reduce their HOA dues and reduce their paperwork, accounting-wise, as who's paying their dues on time. It's also, you know, you have deadlines when you got to pay your dues. If you don't pay your dues by a certain time, you get a late charge. This allows somebody at 11:59 the day before the dues are being paid that they can pay them online and not incur a late fee. So it's really a service to homeowners as well. So I applaud you for bringing it forward.
And Madam Chair, if I may, to Senator Stone's point, one of the things I think, you know, we are always trying to make sure that folks who live in an HOA are getting, and owners have, you know, sufficient notice and lots of communication, and certainly any legal requirements, things that need to be sent by certified mail to make sure that you're getting proper notice. We want to make sure we get that. I think after some legislation from the last session, there were some unintended consequences where we have, and I represent an area where there are several HOAs, one of which sort of being the Sun City Summerlin area, and they were going to start receiving even just mail and postage and all of those as associated costs for things like what was going on at the community center, when the health clinic might be, and these are things that they routinely go to and participate in, and it was, I think, just an unintended consequence of how that bill sort of came through. And so this is an attempt to certainly fix that and to make it a little easier, to make sure there's good communication, but also, you know, for those things that you don't necessarily need to send by mail, that there's a provision that would allow them to receive those electronically and just make sure that people are getting the right information. So.
All right, other questions from members of the committee? Not seeing any. Thank you so much. We will move to testimony in support of SB 378. Anybody wishing to give support testimony is invited to the tables in Carson City and Las Vegas. Looks like we have somebody in Las Vegas. Please go ahead when you're ready.
Chairperson Schweibel and committee members, thank you for the opportunity to speak in favor of SB 378. My name is Carolyn Glazer. I'm a volunteer board president of Red Rock Country Club HOA, which has 1,118 homes. I've been active on various homeowners associations boards for 20 years. I support SB 378 because it clarifies and corrects some of the problems from SB 186 from last session, specifically Section 3. Thank you.
All right, I don't see anybody else coming to either table, so we will go to the phones for testimony in support.
Who would like to testify in support of SB 378, please press star 9 to take your place in the queue.
BPS, do we have anybody on the line?
Yes, this is Mindy Martinez.
Go ahead whenever you're ready.
Hi, hello. My name is Mindy Martinez, and I'm with NFP Insurance. We specialize in insuring homeowners associations. I'm in support of SB 378. Happy to see there is required coverage for the cyber exposure. Thank you.
There are no remaining callers.
All right, then we will come down to Carson City for testimony in opposition to SB 378. Please go ahead whenever you're ready.
Chair Scheibel, members of the committee, Samantha Sato for the record with Queer Nevada on behalf of Cameo, the Community Association Management Executive Officers. We are getting our questions answered and clarification, but as written, we are in opposition today. Thank you.
And anybody in Las Vegas to give opposition testimony? Not seeing anybody, we will go to the phones for testimony in opposition to SB 378.
If you would like to testify in opposition of SB 378, please press *9 to take your place in the queue. We have no callers to testify in opposition.
All right, then let's try neutral. Anybody wishing to give neutral testimony in Las Vegas or Carson City is invited to the table now. Looks like we have somebody in Las Vegas. Please go ahead when you're ready.
Good afternoon, Madam Chair, members of the committee. Sharat Chandra, Administrator for the Real Estate Division. Just here to provide neutral testimony and answer any questions. Thank you.
Thank you so much. Any questions? Looks like you're off the hook for today. So thank you. And I don't see anybody in Carson City to give neutral testimony, so we will go to the phone for neutral testimony on SB 378.
If you would like to testify in neutral of SB 378, please press *9 to take your place in the queue. We have no callers to testify in neutral.
All right, then that brings us to the end of testimony on SB 378. Seeing as there are no closing remarks, I will close the hearing on SB 378 and move to the last item on our agenda, which is public comment. Anybody wishing to give public comment here in Carson City or in person in Las Vegas is invited to the table. And not seeing anybody coming forward, we will go to the phones for public comment.
If you would like to provide public comment, please press *9 to take your place in the queue. There are no callers to provide public comment.
All right, then that concludes our meeting for today. We will be meeting again tomorrow at 1 p.m. Until that time, we are adjourned.